A contract often starts with a promise. If you do this, I promise to do that. I promise to sell you this if you'll pay me that. But at what point is a promise enforceable? The Supreme Court of Kansas considered that question almost a century ago in Greiner v. Greiner. Maggie Greiner's husband, Peter, must have been an awful father. When he died, his will disinherited 4 of their children, including sons Henry and Frank. Henry enjoyed some success but died unmarried and intestate. That meant that Maggie inherited Henry's money and an 80-acre parcel of land. Maggie's son Frank had moved away from home, but now she offered to give Frank some land close to her if he'd move back and live on it. Eventually, Maggie offered Frank the 80-acre parcel if Frank would move onto the land and farm it. Maggie arranged to have some buildings, including a small house, moved onto the parcel. Frank moved onto the land and began working it. Maggie repeated her intention to give Frank the land, both to him and to others. At one point, she said she'd will it to Frank. At a different time, she talked about deeding it to him. But because of hard feelings among her children, she didn't do either. Maggie eventually sued Frank, seeking an order removing him from the property. Frank counterclaimed that she'd promised him the property and that the court should order her to deed it to him. The trial court ordered Maggie to deed the land to Frank, and Maggie appealed to the Supreme Court of Kansas.